The Attorney-General has asked the Victorian Law Reform Commission to review the Crimes, Mental Impairment and Unfitness to be Tried Act 1997. We will be looking at whether the Act is working well and whether it is just and effective. We will report back to the Attorney-General by the 31st of March 2014. The review is being led by the Honourable Philip Cummins, Chair of the Victorian Law Reform Commission and a former judge of the Victorian Supreme Court. Good morning, Philip.
Good morning.
What happens to people coming before the Victorian criminal courts who have mental conditions like a mental illness, intellectual disability or cognitive impairment like a brain injury?
If people come before the courts with a significant mental condition, the court treats them in a special way. And there are two circumstances in which significant mental conditions can arise with people coming before the courts. The first is if their mental processes are so disordered or affected that they are unfit to stand trial. That raises a number of processes. And second is if at the time of the offence they had mental impairment. That also raises certain processes.
Why are there special processes in these circumstances?
There are special processes for two fundamental reasons. The first is that everyone is entitled to a fair hearing when they are brought before a court. And if the person cannot understand what is happening at court, the court treats them by a special process. The second is that a person should not be convicted of a criminal offence if they were not morally responsible for committing that offence at the time of the offence. And that is where the person does not know what they were doing or did not know it was wrong.
What is the law in Victoria that covers these situations?
The law is contained in an Act of Parliament called the Crimes, Mental Impairment and Unfitness to be Tried Act 1997. And that Act of Parliament sets out the criteria for persons coming before the courts with a mental impairment and the processes which apply to them in the court and, importantly, the supervision or control of those persons after the court process is finished. The Act seeks to balance, first, the protection of the community, second, the rights of victims and their families, and third, the rights of accused persons coming before the courts and their families as well.